Do we have everyone?
Good morning, Your Honor.
How are you, Mr. Battaglia?
Doing well, thank you.
Good. You're up.
Thank you. May it please the court, my name is Brian Battaglia and I represent the appellant, Ms. Daryls Fernandez and J&D Financial Solutions. At this time, I would like to reserve 5 minutes for rebuttal. The reason we are here today is to contest the final summary judgment order entered by the trial court at page 293 of the record, which we have brought up to the court from the lower court proceedings. In this particular matter, the court reviews the record in the light most favorable to the appellants. This applies not only to the issues of the record we have brought up to this court, but also shows that there are multiple issues of genuine factual disputes in the record, but also that pertains to the issue of damages awarded, which were not in compliance with established law. And the record also shows the existence of genuine issues of material fact. With regard
Mr. Battaglia, one question as far as the summary judgment proceeding. As I reviewed the record, it does not appear that your client filed anything in response to the motion for summary judgment. Is that correct?
That is true, Your Honor.
Okay.
The issue there, as it relates to the record, Your Honor, is as follows, and I'll be reviewing that with the court this morning. The court entered an order at, again, page 293 of the record, which simply stated that a judgment was entered in favor of plaintiffs against the defendants for unlawful eviction and conversion. There was no finding of fact and no rationale in that order or judgment. So the first issue is that the trial court failed to comply with the summary judgment rule under 1.530. Next,
We don't know that the court failed to comply because there's no transcript of the summary judgment hearing. So the court could very well have announced findings at that time, right?
well, Your Honor, with regard to that, the order itself, the final judgment, was entered 2 days after that particular hearing. I did go back and review the records. There was a motion to tax costs. The court reporter identified was Reporters on Madison. I contacted them. They confirmed to me that they were not at the summary judgment hearing. There was no transcript taken of that particular proceeding. Counsel has indicated and has not provided, and we cannot provide one because there was no transcript. And I would cite to the court some of the decisions out of the second DCA, which indicate that, in fact, if there is no transcript, we cannot bring it to the court. There was a transcript that was filed from the writ of replevin action, which is part of the summary judgment evidence. And we did bring up the record to this court, but the second DCA and Johnson and the Ballard case indicated that based on the facts that we have in this particular case, that's not an issue as it relates to whether or not this particular judgment was incorrect. Again,
Was there any effort to create a stipulated statement of facts or a statement of facts and evidence and arguments that was presented to the trial court for reconciliation in lieu of a transcript?
now there's no stipulation in the record, but the record that we did bring up to this court, which the court has indicated is sufficient as it relates to summary judgment matters, is the record below. And you have that before you. And that particular record clearly reflects that as it relates to the decision, again, there were no findings, but the actual evidence in the record shows that there were numerous disputed issues of material fact and dispute. And again, the judgment indicated that it was entering a damage award of $50,027, and that was based on 42 different line items. And there were over 50 in the record presented in the summary judgment evidence.
Did your client or your predecessor counsel move to strike those affidavits as insufficient?
Your Honor, my review of the record.
I think the answer is no. I think the answer is nobody moved to strike them.
That's correct. That's correct.
Okay, and we don't know based on this record whether there was even an objection lodged at the summary judgment hearing to the trial court's consideration of those affidavits.
Well, Again, that's correct, but we did, again, preserve our arguments when we filed our motion for rehearing under Rule
The
1.530.
motion for rehearing is not a substitute for a response to a motion for summary judgment, is it?
No, I understand that, Your Honor. That's true.
Okay.
That's true. So with regard to the items in evidence, again, and I would like to address the point raised by the court. In the Fuentes case, which is cited in our brief, it's 361 Southern 3rd, 385. The court there specifically held that we're not required to file anything. What the court stated there is that it says may, it's not shall. And the court has a decision to make based on the records that are filed as part of the summary judgment record here in this case. And again, the second DCA in Johnson v. Deutsch, and even in the Ballard case, said you can bring up the record to this court, and that's what we did. And if you look at the actual evidence in the record, which contained the sworn testimony of my client, Ms. Fernandez, which is part of the summary judgment record, there were disputed issues as to the majority of the items that were referenced, and that the appellees, the plaintiffs in the lower court, sought his damages. First of all, with regard to Mrs. Fernandez, she testified as to whether they even existed. She said she didn't see the majority of the items in the unit. There was also the issue of the fact that those particular items and the quantity of the items were not identified. So with regard to that, what they did was they filed an affidavit, and they basically made vague issues relating to the issues of quantity or specificity, such as there was a tattoo machine, $250, sunglasses, $500, phones. We don't know the number of phones. It says 1,000, clothes and shoes, a bedroom set. So again, with regard to and then the cash, she said she never saw any cash in the unit, $21,300. So that is in the record, and that is sworn testimony where it's disputed as to the existence of the very items that they were awarded damages for. And then the issue of
I ask you a question about the award of damages as distinguished from the liability. When I looked at some of the affidavits, it had language about plaintiffs have not been able to recover these items, and the estimated value of these items is. I note that it doesn't say a date of conversion, it's the date of taking for valuation. The other part that concerns me is that damages appear to be unliquidated. Is there any legal way that these issues have been preserved for us that we could actually address them in terms of sufficiency of the evidence in light of this record?
Yes, they're in the record that we brought before this court. The specific issues are outlined in the law as it relates to what is required is specifically, for example, in the Gillette case out of the second DCA we cited, there's also the Lilly versus Bronson case. The standard is the damages is the value at the time of conversion, not the original cost or replacement value. And if you look at the transcript, and I believe that's at page 200 to 201, Mr. Morales, the appellee, there was only one receipt that was referenced, and that receipt was for the purchase, he said, of a bedroom set. So he was actually using the purchase price for the valuation. And if you look at that item in and of itself, that's contrary to the law, because you cannot use the actual original cost of the item. It's, again, the value of that particular item at the time of conversion. And you're right, Your Honor, in the affidavit, they don't really say any specific time frame. There's no quantification of these items. There's no specificity. And again, most critically, in this record below, the disputed facts are very clear that Mrs. Fernandez stated very clearly that she didn't see the majority of the items. There were probably, I think, 10 items that were provided and returned. All the other items were not located because she said they were not in the unit. She didn't have them and she did not see them. So that's a disputed fact that goes directly to the issue of a $50,000 plus award of damages when there are disputed material facts as it relates to that very issue, which is contrary also based on the record to the legal standard that must be applied. Again, the Appley's own testimony on that one item was that he located the receipt for what he paid for it. And that's what's apparently in the affidavit as it relates to his valuation. And again, there are no dates. There's no specificity on all these items. For example, on a PlayStation, he identified that as being $750. You can buy a brand new PlayStation for $500. So
Is that established in the record, Mr. Battaglia?
no, it's not in the record, Your Honor. No.
So, one of the questions that I am concerned about is under the new summary judgment rule. It says that if a party fails to address another party's assertion of fact, then a court may consider that fact as undisputed. So we have the appellee's affidavit saying, here's the value. As Judge Casanueva points out, it's not a particularly detailed affidavit other than a valuation, but there's nothing in response by your client. So what precludes the trial court from considering that fact as undisputed?
Again,
I'm not asking about your client saying, I don't even have the stuff, but as if we get past that issue, how do we reverse the trial court to say that you really shouldn't have awarded it because it's not clear as to the value, but your client didn't challenge the value? Well,
again, Your Honor, if you look at the transcript, and I just want to point again to the second DCA's case in Johnson v. Deutsch, where it said it's not necessary in every case to have the transcript. That here we brought up the record. And if you look at the record, the judge, this is summary judgment evidence that the appellees filed before this court. And in that, if you look at that transcript, what we know is specifically that the court made another error, as noted in our brief. It considered the credibility of the two testifying witnesses. That would be Mr. Morales and Ms. Fernandez. And what the court did at the very end of that transcript said, I don't believe you, Mrs. Fernandez. I believe Mr. Morales. And that was what they relied upon as summary judgment evidence. And that is completely contrary to the standard. And again, the Fuentes case, which is one cited in our reply brief, clearly indicates that under this rule, you can't, as a court, simply accept the fact that if there's no response filed, grant summary judgment. I'm sorry.
But your client, in her testimony for the Raplevin hearing, she did not challenge any of the valuation, did she? She didn't present any evidence that that bed set could not be worth X number of dollars, or that game set could not be worth so many dollars. Or there's no indication that she challenged that on an evidentiary basis.
Yeah, well, no, her lawyer did. I believe the name was Woody. He raised the
Child
objection.
note in the transcript, the lawyer's statements are not evidence.
No, but
So
he objected, and then he.
Hang on, she did not present evidence challenging the valuation. Her testimony was, I had the right to go in there. He had no right to, they had no right to occupy the premises. I didn't take anything at all that didn't belong to my daughter. There was nothing regarding valuation, correct?
Respectfully, Your Honor, I think there was, because the objection noted in the record by Mr. Woody related, I think it was 403 or 408, but that goes back to the issue of the receipt. When he said, listen, there are no receipts here. There's nothing to support what this individual, Mr. Morales, is saying. That's when Mr. Morales said, oh, I have one receipt, and he tried to use the actual acquisition value of the particular item, which I believe was a bedroom set. And again, you can go to 200-201 of the record. And so there were disputed factual issues as related to the valuation. There were also disputes about whether the property in itself existed, because Ms. Fernandez testified she didn't see most of it. She didn't clearly see the $20,000 or so odd dollars in cash, and she didn't see the other items. And Mr. Woody went through each of those items in the record. Right. So, and again, we know what the standard is as it relates to the issue of conversion, as I stated here to the court. So with regard to the particular matter here, again, it was unduly speculative based on The record in this case has concerned the issue of conversion and damages and the award of $50,000. Again, I've noted some of the things that they identified. The affidavit that they filed, again, didn't have any particular dates. It didn't quantify anything about the standard to be applied. And we know from their transcript that at least on the one item, they were using the acquisition purchase price, which is clearly contrary to stated law. As to the other items, Your Honor.
Mr. Battaglia, you are at your 5 minutes, but use them as you please.
Okay, thank you. And I appreciate the time, and I'll rebut counsel's statements.
Okay, thanks. Okay, Mr. Apolli, it's your turn.
Yes, may it please the court, Felix Montanez on behalf of the appellees. Your Honors, after the answer brief was filed, a case directly on point was issued by this case. That's Ballard v. Bank of America, NA, 365 Southern 3rd, 1219. And I'm reading from parts of it. It says, in this appeal, Ballard points out to the trial court's failure to detail its reasons for granting summary judgment in the written order, but he fails to
Did
acknowledge.
you give us a notice of supplemental authority on that, Mr. Montanez?
No, Your Honor.
Have you shared it with opposing counsel?
No, Your Honor.
Yeah, you probably need to, file that notice.
Yes, Your Honor. I will. I will do so. Your
It is, Mr. Montanez. I have a copy of it.
I'll just get it from Judge Casanway.
Yes, Your Honor. I will supplement and include that. The court in Bank of America versus Ballard held that that if a ruling on the summary judgment was made at the summary judgment hearing and there's no transcript of that hearing, then it's sorry. I'll just read from the court's language. It says that issue here is a trial court's failure to provide specific reasoning for granting the summary judgment either orally at the hearing or in its written order. Had the trial court granted summary judgment at the hearing, we could have denied relief on this issue due to Ballard's failure to provide a transcript or statement of the proceedings pursuant to Florida Rule of Appellate Procedure 9.200, subsection B and subsection 5. So that's what happened in this case. There was no transcript from the summary judgment hearing. It is the appellant's responsibility to provide that full transcript. And because there is no full transcript, it doesn't allow the court to review what happened in the lower courts. It's not the trial court's responsibility to secure a transcript for the hearing. The trial court's actions don't become reversible error by virtue of the parties failing to secure a transcript. As Your Honor's
Mr. Montanez,
yes,
Mr. Montanez, I'd like to move to another issue, which is the transcript from the Raplevin hearing, which your client put in as part of its summary judgment package. The trial court at the end of that hearing made findings as to credibility of the parties and ruled in favor of your client. Does that have any value for purposes of summary judgment? And if so, under what authority?
Your Honor, I don't know that I have any value for the purpose of the summary judgment hearing.
Let me maybe rephrase it. Mr. Battaglia points out that there was conflicting testimony at the Raplevin hearing, and the trial court made certain determinations as to who the court believed and ruled accordingly. Does that have any binding effect for use at summary judgment?
I don't believe it does. But
So if it doesn't, then are there genuine issues of fact based on her claiming, the appellant claiming, I did not take that property?
No, Your Honor, because that transcript was not cited by the appellee in opposition to the motion for summary judgment.
But your client submitted it in support of summary judgment. So it was a record for consideration, wasn't it?
Yes, Your Honor, it was a record for consideration, but the lower court's not required to sift through the entire record to determine what potential issues there are for summary judgment. He's only required to review the parts cited by the parties, and the defendants in this case, sorry, the appellants in this case did not submit a response. Did not cite to any part of that transcript. They only cite to that transcript now on appeal. So the trial court was within its authority to consider all the facts stated in the motion for summary judgment as uncontested, and for that reason, they were able to grant summary judgment in this case. I'll point out as well that Rule 1.510 regarding the summary judgment rule, it says that the non-movement shall prepare a response at least 20 days prior to the hearing. They're not required to do that ahead of time. It's sorry, the word is must. It doesn't say shall. Must. So the failure of the appellant in this case to file a response allows the court to deem all the facts stated therein as uncontested. In the briefs, the appellant argues that that Chapter 83 of the Florida Statute, the Landlord-Tenant Act, doesn't apply to this case. We believe that it does. Chapter 83 defines a landlord as the owner or lessor of a dwelling unit. It is undisputed in this case that the appellant was an owner of the property. Additionally, the statute defines a tenant as a person entitled to occupy a dwelling unit under a rental agreement. The record in this case, it is undisputed that the tenants rented the property from Julio Manso. This property was subject to a dissolution of marriage action, and the title to the property was somewhat in the air. At the time that the rental agreement was made, there was a non-final judgment of dissolution of marriage awarding the property to Julio Manso, who rented it to my clients. But nevertheless, the statute does not require privity between the landlord and the tenant. The appellant qualifies as a landlord pursuant to the definition in the statute, and my client qualifies as a tenant pursuant to the definitions in the statute. And 8367 says a landlord of any dwelling unit governed by this part shall not prevent the tenant from gaining reasonable access to the dwelling unit by any means, including but not limited to changing the locks or using any boot lock or similar device. There's a lot of citation in the records by appellant regarding conversion and whether the property is alleged to have been owned by my client. I believe the summary judgment evidence is undisputed that my client owned the property they claim to have been converted. There was nothing submitted in contradiction of that.
Mr. Martinez, let me ask you this with regard to contradiction. The rule for summary judgment says you are entitled to summary judgment as a matter of law. The law also in the rule says that the affidavit submitted by your clients has to be such as would be admissible in evidence. And the rules of evidence and law for conversion says the date of valuation is the date of the conversion, not its purchase value or its replacement value. So doesn't the trial judge have an obligation as a matter of law to look at your affidavit, even if uncontested, and ascertain whether that measures up to the legal standards? If you haven't carried your burden, arguably, for the purposes of this question, then the trial judge would have erred in granting you summary judgment as to valuation, since the affidavit attached has no date of valuation, no methodology of valuation, and arguably wouldn't meet the requirements that the evidence requires and the case law requires as of the date. So the fact of response doesn't automatically, ipso facto, give you a ruling, does it? Doesn't it have to meet the legal standards? Isn't that what the judge is supposed to look at?
Your Honors, yes.
There's a lot in there. Take your time and wrap it up, but I wanted to not do it piecemeal with you.
Yes, Your Honor. So the affidavits do cite to estimated value, which probably could have been done
As of what date?
And it doesn't cite a
The law says it has to be at the date of taking, right? So arguably that affidavit is legally insufficient. How then can the trial judge say, as a matter of law, you are entitled to damages, a judgment as to this amount of damages? I'm not talking about liability. I'm only talking about this side. And that concerns me. So I don't get a chance to talk to you again when we go back to talk about it. And I want to know what your response is. Mr. Battaglia has given me one. I want to get yours too.
Yes, Your Honor. Well, in this case, the facts of this case, the time of the taking and the time of the ruling are not particularly far apart. This is not a case that was litigated over years, and it wasn't challenged. That objection was not raised by the defendant or anyone. I don't. The data evaluation just wasn't brought up in any of the on the record or in any objection at all. So I believe the court. I believe the court could have considered that fact uncontested because it was cited as the proper valuation.
The section says it may consider. I think that's someone pointed out earlier. May, but doesn't the rule impose an affirmative burden to do it according to law? Take the fact and then measure the fact. It says this is the value, and the law says value has to be established at least as a particular date, and it fails. Therefore, no entitlement on this. Try again. Give me a new affidavit.
Yes, Your Honor. And
I mean, I'm just playing rhetorical. I'm just trying to make sure I grasp it, because these damages, in my view, appear to be unliquidated. And so there's usually a question of fact as what, or opinion, or what the valuation would be.
Yes, Your Honor. I think that the data valuation never came up in the lower court.
The argument would be the other side failed to point that out to the trial judge. Therefore, that issue is inferentially waived, and the trial judge may consider this to be a fact under the rule. Is that the path you think I should take in analyzing this?
Yes, Your Honor. I believe that issue was waived because it wasn't raised at any point in the lower court. Also, like I said, the timing in this case, it's not. I don't. The
not a long time between events.
Excuse me. Yeah, there wasn't
a long time between events.
Yes, Your Honor. So maybe it was taken as somewhat for granted in the lower court. The data valuation, but I believe that issue was waived because it wasn't raised by any by anyone really. So
thank you.
Mr. Martinez, one question on that same point. At the hearing on the replevin, there was an objection, I think, as to relevance and maybe as to authentication regarding photographs of certain pieces of property. Did the other side object as to the valuations and the exhibits that set out the valuations? And Mr. Battaglia will undoubtedly respond to that as well, but I don't recall that there was a specific objection on valuation, but maybe I've missed that.
I don't recall one either. I'll also point out that about half of the judgment was based on cash. 23,000, but no, I don't recall there being any objection as to the valuations at that point. I think there was sorry, yeah. So I don't believe that there was any objection to the valuations at that point. There is some question as to the appellant raises issues of why weren't receipts produced or photographs produced. The facts of this case is that my clients were living in a house. They left for a short trip, and when they came back, all their stuff was gone. I don't think it's reasonable to expect them to carry receipts with them or pictures of all their belongings with them. It's just not, people don't do that. It's not a reasonable thing to expect. And with that, Your Honors, I have nothing further to add. Thank you.
Okay. Thank you, Mr. Montanez. Mr. Battaglia, you have 5 minutes for rebuttal.
Thank you, Your Honor. Again, with regard to the record, the issues as it relates to that, the damages awarded, they were speculative, indefinite, and unreliable. The two affidavits.
Was that objection made at the hearing on the replevin?
Your Honor, with regard to the issue of the amount, again, there was cross-examination by Mr. Woody, counsel for the appellant at the time. I believe there were issues relating to the receipt. There was an objection that he made as it related to that particular failure to produce those, because those go directly to
Let me just sort of hit the nail on the head. Was there an objection that the testimony was an improper valuation because it did not address the current condition and was relying on purchase prices? Was there an objection to that effect?
Your Honor, candidly, I don't recall if there's a specific objection, but I would tell the court this, that when he cross-examined Mr. Morales and he raised those particular issues, that in essence was the matter that related to the valuation. And you go back to Mrs. Fernandez's testimony about not.
So the cross-examination was, you don't have receipts for all these things you're claiming. And the response was, that's correct, I don't. She even stole some of the paperwork that was in the apartment. But I don't think, or at least do not recall there being an objection that the testimony to establish valuation was incompetent based on the wrong standard.
Your Honor, with regard to that particular record, again, we brought the record up. I think based on our evaluation of the case law and what is required, there was no particular date in terms of the evaluation. We didn't waive it. It was asserted because at each step, at least at that process, there were objections to the fact that, again, it was speculative, it was vague, the items were not there according to Ms. Fernandez. So I don't believe there was a waiver at all by the appellants or the defendants in the lower court proceedings. And the one thing I wanted to point out is that this hearing was 15 minutes by phone. There was no court reporter there. I attempted to find one. There was none. And I confirmed that with the one court reporter who was at the replevin hearing. And the case law in the second district is that if you bring up the record, which we've done, and this is the summary judgment evidence that they relied upon to obtain this judgment of over $50,000. And if you look at that record, the summary judgment evidence that they submitted, and in the Fuentes case, the fact that there was no response by this pro se defendant at the time does not permit the court to grant carte blanche the summary judgment, because in that record, Your Honor, it's clear that there were multiple disputed issues of fact concerning the existence, the quantity, the specificity of those items. And in addition to that, Judge, the court, if you read the latter part of the transcript from the replevin, which was summary judgment evidence, he states on the record that he's evaluating the credibility of the two parties, which is contrary to the law for summary judgment. It's not permissible. And that in and of itself was a defect and deficiency as it related to the final summary judgment. And that was the evidence that they submitted. And I would submit to this court that has a matter of law and has a matter of the multiple disputed issues of fact in this record, that this was not appropriate for the entry of a final summary judgment of over $50,000 based on that record, which we have brought up to this court. And so for those reasons, Your Honor, I would request that the court reverse and remand this particular final summary judgment back to the trial court. And I thank you all for your time today.
Thank you, Mr. Battaglia. Thank you both very much. In order to leave our screens, you need to click the leave button, which is on your Zoom screen. It's in red, I think, and you will disappear for the day.
Thank you.
Thank you.